Good morning, everyone. We're going to go ahead and get started now. My name is Kai Bryant. My pronouns are she and her. I am a digital accessibility graduate assistant at UNC Greensboro. This session is being recorded and will be shared after the conference. We will have professional captioning services and ASL during today's session. You can access these settings and turn these features on and off in the Zoom menus. Please be sure to use the Q&A feature to post your questions. You will have the option to post anonymously if that is what you prefer. If you have any issues with Zoom, please let us know in the chat. We have someone monitoring who can try to assist you, and you can also email digital_accessibility@unc.edu. Please remember to complete the survey after the session, and there is a link and a QR code that will be displayed at the end. But thank you for today, and we are going to go ahead and get started with session 2. The title of today's session is one section here is Access and Practice, Navigating, Defending, and Avoiding Digital Accessibility Litigation. And our presenter today will be Derek Dittmar, who is a civil rights and accessibility attorney. Give me 1 second here, and I'm going to go ahead and share his bio. 1 second. Derek Dittmar is an associate at Lewis Brisbois Raleigh's office, part of the general liability practice. He holds a JD from Campbell Law, an LMM from Nottingham Trent, and a CPA CC certification. His expertise includes civil litigation, digital compliance, and also digital accessibility. Outside of law, he does enjoy craft beer, music, and spending time with his family. So thank you, and I'm going to go ahead and let Derek take it away.
Thank you so much, Kai. I really appreciate it. It's funny. The reference to craft beer really makes its way into more bios than I would expect. It's so nice to meet everybody. Again, my name is Derek Dittmar. It's really, really good to be here. And let me start with just a couple housekeeping issues. The first is, as much as such a thing is possible on Zoom, I would love this to be a conversation. Chelsea may be one of the first to tell you I have no issue being interrupted and asked questions. And so as we're chatting, if you have a question about what I'm talking about, please don't hesitate to put it in the Q&A or put it in the chat. And then I'm going to ask Chelsea or somebody else sort of in the UNC side that if you see something come in, please feel free to jump in, interrupt, and we'll make this as conversational as we can. Does that sound good?
That sounds
Perfect.
great, Derek. Yeah, Kai and I will interrupt you if we have questions come in.
I didn't think I'd have to fight you on that one. Yeah, that sounds great. The other thing I want to just take a moment of personal privilege to say is thank you to all of our attendees. So I am, in addition to being a lawyer who is blind, who does disability access work, I am blind. If we were here in person today, you would see completely sprawled out asleep next to me is my 2-year-old yellow Labrador guide dog, Valentino. And so I am a proud graduate of K through 12 public schools in Wake County, North Carolina. I did my law degree here in North Carolina. I've had a sibling and family members that are teachers in this space. The work that everybody does on this call, whether you are active in digital accessibility, whether you are curious about digital accessibility, whether you logged into the wrong webinar by mistake and decided to hang around, you all are doing such remarkable work that likely can feel from time to time like it goes unnoticed. And I just want to say, as somebody who's been through the process, I graduated undergrad 8 years ago and still keep in touch with my digital accessibility advisor there. You all are changing lives on the daily. And I just want to thank you for that. I also want to take a second and thank Chelsea and her team. UNC's program for digital accessibility is remarkable. It is filled with dedicated, passionate, hardworking, and knowledgeable people that are doing great work for the students and the faculty and everybody who benefits from those students and faculty. So thank you for what you do. Okay, that's me being nice for 2 minutes. Let's talk about accessibility litigation, all right? So what I mean by that is when somebody alleges that a digital offering or a provided service is not accessible and they decide to go to the courts. And so the title of today's presentation really gets into navigating, avoiding, and defending digital accessibility lawsuits. The three biggest things I want you to keep in mind today, these are sort of the North Stars for digital accessibility. Don't panic, don't wait, and don't rely, okay? I'm gonna come back to those time and time again, but those are the three things that we're gonna wanna remember. Don't panic, don't rely, or don't wait, and don't rely. Specifically for organization today, I did not provide a PowerPoint. If somebody afterwards wants a copy of my presentation outline because you learn better with written material or it's helpful, I'm happy to provide that. But as a general overview, today we're going to start with what are the biggest areas we're seeing risk in digital accessibility litigation. Second is what happens when that accessibility litigation happens and you get sued. And then the third is what can we be doing today? My least favorite type of presentation, and luckily one I very rarely see in the accessibility space, is alarmist, cure all these problems without any sort of solutions that we could take today. So I'm going to try not to do that to you. The reason that I am here today, the reason that I am speaking on this, in addition to being somebody who lives the accessibility journey day to day, is that I work largely in the space of digital accessibility litigation defense. There aren't a lot of disabled persons who are in this space. And so the reason that I actually moved to the firm where I currently am, and one of the many reasons I love where I am, is that according to UsableNet's 2023 year-end roundup, Lewis, Brisbois, Bisgard & Smith is one of the top 10 biggest accessibility defense law firms in the nation. We have a thriving accessibility practice with partners located in Charlotte, North Carolina, New York, and over just outside of the Bay Area in California. Those are the co-chairs and chair of our accessibility practice that handle a lot of accessibility litigation, whether it's administrative questions, so people that are being investigated by the Department of Justice or the Department of Education, or whether people have just been sued. We do this work a lot, and it matters to us, not only that we can help our clients navigate the accessibility litigation space, but also that we can make things accessible. You know, I will tell you, as somebody who works on the defense side, a lot of what I do is initial quick auditing for people's services. You know, that's a service that the firm provides for people both during litigation and before litigation to try to pinpoint issues that may give rise to litigation. And I've been with the firm a little under a year, and I have seen and been able to be a part of more change with more websites that come in and say, are we accessible? Or this person alleges we're not accessible, and help guide them in their journey of accessibility. In the less than a year I've been at this firm, I've gotten to do more of that than I have just as a normal consumer. Because unfortunately, a lot of people's responses when they get an accessibility request or complaint is to panic and not respond to it, or to hope it will go away. And so I'm very privileged to be in this space, and I'm excited to share this information with you all. So the first area we're going to talk about is what is the biggest area of risk? So what trends are we seeing in digital accessibility litigation? So again, digital accessibility litigation, I use that term pretty broadly. What I am referring to there are any sort of administrative or judicial case where the plaintiff is alleging that the defendant is not accessible. Most of these cases are coming under the Americans with Disabilities Act. There is a growing number of these cases that are coming under state acts across the nation. That matters for a couple reasons. Most of them are largely academic to the folks on this call, because the North Carolina Persons with Disabilities Protection Act really doesn't have any difference in standard than the ADA does. It hasn't been updated in a long time. It actually predates the ADA. And other than having slightly more broad protections for service animals in North Carolina than are protected under the ADA, it's really not that big of a factor. Frankly, most people forget it exists. So mostly in North Carolina, we're worried about a couple different areas of the law. The only one I'm really seeing accessibility fought on is the ADA. And so the Americans with Disabilities Act is a broad coverage, prevents discrimination against covered persons with disabilities by covered entities. And there are several titles to it. The one that is most relevant to the folks on this call is probably going to be Title II, which is state and local governments. That matters because it's also really anybody that, and there are very complicated tests for this and elements that you have to weigh for the court, but pretty much any public school, university is going to get covered by Title II. And so litigation largely is under Title III. And Title III is places of public accommodation. That's your private companies, your bars, your restaurants, your hotels, your salons, your stores. I have to remind my colleagues in the bar all this all the time, your lawyers and accountants' offices. The reason that the Title III litigation matters to us here in Title II land is because they're both interpreted by the Department of Justice. And so courts will very regularly look at guidance between the two, and court decisions in a Title II case to look at Title III and vice versa for guidance and to help them navigate these issues. So looking at the way Title III cases go really helps us sort of expect how Title II cases will go. Let's jump in a quick history machine for a second. If we have any history teachers, this is sort of my boon to you. Years 1990, 1991, when the ADA is passed, right? We are coming on the tail end of all of the disability rights movement conduct in the 80s, the Capitol crawl, where people got out of their wheelchairs and physically pulled themselves up the stairs of the Capitol in DC to demonstrate inaccessibility of buildings. We're coming off of the time when the rolling quads and other groups in Berkeley are 20 years old at this point, but haven't made the same stir in the American politic as we would see from something like the civil rights movement or even the LGBT movement. And so most disability knowledge comes from the physical model of accessibility, thinking about what can we do to make the human machine work better? What can we do to assist the human machine? And when the ADA is passed, the primary focus, other than employment, is on physical structure accessibility. And so you see there are two different sets of guidelines, both very similar. The main one is the ADA accessibility guidelines. They're these massive, detailed, usually called building codes, promulgated through the Department of Justice that get into the details of what an accessible building means and what it needs. And it gets down to the level of using a level, literally, to test the slope of a wheelchair ramp, because it has to be at a certain slope. Braille signs need to be X inches off the ground on the same side of the door as the handle. It is that detailed. At this time, less than 15% of American households have computers, and the internet is still only used by researchers and scientists. And so computer regulations, accessibility regulations, really aren't in anybody's mind at this time. So there is this huge rush of drive-by litigation. And I'm going to explain why it's called drive-by in a second. But this drive-by litigation that starts to happen from plaintiffs' firms that are going and using these ADA accessibility guidelines and testing the physical compliance of random businesses. And when I say random businesses, I do mean random businesses. It got to the point, part of these guidelines has a requirement for how many accessible or handicapped parking spots we have in our parking lots. So these people would drive by the road and count the handicapped parking spots and take a note of which ones were not compliant and get home and file those complaints. Now people just do it on Google Maps on their couch. So that is sort of the origin of where we saw accessibility litigation under the ADA, and it really backfired in a lot of ways. One of the reasons that Congress had to pass the ADA Amendments Act in 2008 was because the Supreme Court of the United States was interpreting the ADA very limitedly. There's a case, Sutton versus one of the airlines, from about 2000, where the Supreme Court basically says the standard for who is covered under the ADA is based off of you with every possible accommodation you can get. And so as one reporter said around the time, I really need to call the Supreme Court and thank them for curing my diabetes, because they say if I take my insulin, I don't have diabetes anymore and I'm not disabled. That is one of the reasons the ADA gets amended in 2008, around the same time we see WCAG 2.0. So there's a couple through lines here that matter to what's happening today. The first is people are seeing an opportunity to make a living as career plaintiffs. And firms are seeing an opportunity to make a living by working with career plaintiffs. Something like 80% of the cases that were filed last year, and I'm going to put an asterisk there because there's a notable issue with that data, but something like 80% of the cases filed last year, according to one source, were done by the same 7 or 8 law firms and the same several plaintiffs. And this is a high volume, low income, but profitable area for digital accessibility litigation, because the ADA is what we call an injunctive law. What that means is you don't get damages for winning under the ADA. You don't get pain and suffering. What you get is an injunction, a court order requiring the defendant to comply with the ADA. So if they allege your website isn't accessible or your offering isn't accessible, if you lose, you have to go make it accessible. The other reason it's profitable for plaintiffs' counsel is because oftentimes the court will award attorney's fees. So you as a defendant are sitting there thinking, okay, if I fight this thing, I'm probably gonna have to go make it accessible anyway. And I'm gonna have to pay my lawyer and my experts and auditors and tech people and plaintiff's lawyer. The other thing to keep in mind is the number of repeat litigators. That is, somebody who has been sued over this before and gets sued over it again is going up exponentially. There are, I am sure, Google groups, email groups, WhatsApp groups of some of these plaintiffs, because there are not many of them, that will reach out and say, I just got a lot of money from the, fictional bank on fictional street. Y'all should go for them. I heard an intake of breath. I want to make sure I don't have any questions at this point, because I know I'm hitting you guys with a lot. I hope you got your coffee. This is a lot. So to finish up with a little bit about what we're seeing here, it's very interesting. If you look in the Fourth Circuit, North Carolina, South Carolina, Virginia, West Virginia, Maryland, there's really not a lot of cases citing to the Web Content Accessibility Guidelines. There are really only 2 big ones that impact North Carolina. The first one is Fernandez versus Duke University. This was a case where Fernandez was alleging he was an alumni of Duke and he was not able to use Duke's alumni portal. The second one is Bohm versus UNC Health. I'm going to be intentional about what I say about this case because our firm is involved representing UNC. This is a case where the allegation from the plaintiff is that UNC's services for providing medical records are not accessible. Those are the 2 areas where courts are citing WCAG. Reason that matters is exactly what Judy said, which was, geez, just one of the best presentations I've heard in a long time. Now that Title II has incorporated the Web Content Accessibility Guidelines, we're going to see more reference to them. And I'm going to go back and connect the dot for a second, right? When we talked earlier about in the early 90s, when they made those ADA-AG guidelines that gave rise to more accessibility litigation, and people started using those as a basis, people have already started using WCAG as the basis for their litigation. That now that it's officially, I guess as of 2026 or 2027, depending on your size, now that's officially part of Title II, I am going to be flabbergasted if it's not the exact same area. And in fact, we're already starting to see it. So that's a little bit of an overview about what we're seeing in the litigation space, right? I will say one benefit to the people on this call: education systems, at least under relying on web content accessibility guidelines, are not the primary focus for these repeat litigators. The main focus right now is going to be smaller companies, so under 25 million a year, that are doing e-commerce and they're moving under Title III. There are a lot of reasons for that get a little bit complicated. Easiest among them is somebody in New York can try to buy, I don't know, guitars from a guitar store in Raleigh to have shipped to them and have the ability to have standing under the courts to bring that case. So it's very easy for people all over the nation. In fact, one attorney just got his professional discipline was, I guess, overturned for due process reasons, but not related to this action. But he got disciplined because he was filing something like 13 of these complaints a day and trying to tell the court when he was getting his attorney's fees that each one was taking him 3 hours to complete, and he was working a full-time job as a public defender. Now, again, this due process argument was used on appeal to overturn that, so he is no longer disciplined in that space that I've seen. I was not a math major, but I assume there's somebody here that teaches or is good at math. I'm really not sure how 13 3-hour briefs or complaints a day plus 8 hours working in a 24-hour day works. I don't think it does, but somebody can confirm that for me. So the next question that we're going to get to, sort of part 2, is, okay, we know what these litigation experiences look like. We know what these plaintiffs are looking for. What happens if they're looking and they find me, right? Well, it's kind of going to depend on the plaintiff. And there's 3 types of plaintiffs that we see in this space. The first is going to be somebody who is genuinely trying to use a piece of software, a mobile app, and cannot do it, and has asked, usually will ask the person for help, the producer, and get no response. In that case, it's usually a pretty easy to navigate case because we're all wanting the same thing, which is to make an accessible product. And it's incredibly frustrating that when all of the government money was going into the development of the internet, nobody was saying, hey, let's try to make sure it's just by definition accessible. And then when all of the money goes into training coders, at least up until the last couple of years, very few people were saying, and let's teach coders and web developers how to be accessible and how to create accessible spaces. And so because the larger, I guess, power dominant spaces pass the buck, it's down to the person with a disability to, the only remedy they have is to either complain to an administrative organization or bring a lawsuit. And then it's up to usually a small business or a school or a not well-funded group that has to respond to that. And so it's a little bit of gladiatorial combat for the entertainment of the masses that is incredibly problematic. That is the first type of plaintiff we're seeing. It's like, I have no other option but to get into this. The second type of plaintiff that we're seeing, and I don't think this is particularly common, but they do exist, are the people that are looking for money, okay? And there are folks out there that are basically working with small mom and pop firms to represent them, and they will split the attorney's fees, or they will get paid a certain amount by the firm every time they sign up as that person's plaintiff. There was a gentleman in Florida who got in some professional bar issues. He and his client was, I believe, blind, and they were suing. You know, when you pump gas, the little screen that's showing you advertisements, they were suing over that screen not being accessible. And they were suing pretty much, I swear there was probably an Excel spreadsheet somewhere, I would have to guess, of gas stations in Florida. Where they got in trouble was, again, the ADA is injunctive. The goal is to fix the problem. But when they were entering these resolution agreements, consent orders, they had nothing in there about fixing the issue. It was just, and you pay me 10 grand and I'll go away. And then they were splitting that fee. That is the second type of plaintiff we'll see. That type of plaintiff is very frustrating to me as an attorney and to me just as a member of the community. But I also recognize with income inequality and with difficulty becoming employed as disabled people and the need to put food on a table and maybe take care of families, I get that a little bit more for the disabled person than I do for the firm that's just seeing it as an opportunity. The third type of plaintiff that we're going to see is this combination of two. These are usually the folks that call themselves testers. Anybody had any experience or heard about these testers? Okay, that's right. We're all muted. Good. I'm going to assume everybody's very, very engaged. This is great. So testers are people who view themselves as accessibility advocates. I will make sure I leave time for questions, and thanks, Chelsea. Our testers are people that view themselves as accessibility advocates and as members of the disability rights movement, and who are using the ADA as a vehicle for social change by suing wherever they see an issue. And they view kind of what we talked about earlier with the ADA being their only avenue. So if that's the only avenue they're given, they're not bad people for taking that avenue. Most of these people also do get some income for their work. And so testers can be a little bit of an issue as far as especially repeat litigation. But let's talk about, knowing these three types of plaintiffs, what happens when a case comes in. So the first thing that usually happens is a demand letter. Hey, your offering is inaccessible, fix it or I'm going to sue you. Usually our firm doesn't get involved at that point because people just sort of poo-poo it. That's not always the best idea, but that's what they will do. And then we'll see a legal complaint filed. Most of these complaints have been filed in federal court under the ADA, but we're seeing so many more filed, especially in places like New York and California under state laws. So it's very hard to track how many of these cases are filed. So the first thing that we are going to do is review that complaint the same way we would do to anything. The complaint is where they allege what's wrong. And usually in that complaint, they're going to be specific enough to talk about what software they're using. I am using the JAWS screen reader with Chrome. That's very helpful for our next step. But we're also checking for jurisdictional things. Did they sue the right person? Did they serve them properly? Did they sue the right court? Is there some statute of limitations that matters? Statute of limitations is a legal concept that means you cannot sue after a certain period of time has passed. And every state statute of limitations on that is different. So if you're saying, I tried to use your website in 2018, and now I'm suing you in 2024, that's probably going to be tough for you. We will sometimes ask plaintiffs' counsel, can you provide proof of the inaccessibility? And then they'll send over some sort of automated test, or usually some of the bigger firms have people on site that are alleged experts that just have the same copy and pasted affidavit with the same problems. The reason that we ask for that information and the reason that we review that complaint to know what software they're using is so that we can conduct our own audit. Now, I had heard a question earlier, what does an accessibility audit look like? Usually an accessibility audit is going to be 2 steps, right? The first step is automated. There are very, very good tools that can be used to do a quick automated scan of a website or a document to see if it's accessible. I want to be extraordinarily clear with you. An automated test is not complete. An automated test, depending on who is advertising it, can maybe get 60% of the issues. I question that assertion a little bit. Automated tests are like running spell check. They're going to catch big outliers, but I have cited to way more general statutes of North Carolina than I am proud to admit. And so we all know spell check isn't everything. The benefit of using an automated test is A, it identifies the big low-hanging fruit, and B, especially for the newer firms that are getting involved in this repeat litigation, they're relying entirely on audits and just digital audits. And so if your main site is clean under these digital audits, that's very helpful. In almost every one of these cases, plaintiffs are looking for settlement. And that settlement is pay X amount, which includes attorney's fees and settlement. So you're compensating them for leaving you alone, and agree to have the item fixed within X number of weeks or months. This is unfortunately the best goal for a lot of folks, because up until April of this year, when WCAG started becoming part of Title II, WCAG was not included in the ADA. And so the first thing that we would do is try to get it dismissed, a complaint, and you can't get it, there's a case law that talks about you can't get a complaint dismissed just because you show proof that it's WCAG compliant, because the plaintiff's going to show proof that says it's not. I have done work, I'm being intentional about what I share here. I have read things from a case and observed work where the defendant was sued. This was under Title III. The defendant was sued and did a remarkable job remediating their website. Took it to one of the best examples of accessibility that I've ever encountered. And plaintiffs still had an affidavit from an expert saying, I reviewed the website on this day, and then I reviewed it after the alleged remediations were done. They have made no noticeable changes to their website. There is no fix. It's still inaccessible. And that is enough to basically defeat it until you have to go all the way to trial, which is incredibly expensive. So the best outcome that we have a lot of the time is trying to negotiate settlement. And the way things that you can look for that are often factors to help in settlement is, what are you doing to fix your website? What steps have you taken? I don't want to get too much into the specific factors that we look for there, because that's what we do as attorneys for folks. It changes time to time. I will say a lot of the benefit of our firm is that we work with a lot of these same plaintiffs, and we know the typical asking prices in different parts of the country.
Hey, Derek.
So, yeah.
Hey, I'm sorry. We
No,
do
you're
have
not.
a
Don't be
question,
sorry.
if you don't mind
Heck
me
yeah.
popping in. All right, awesome. So here the question is, with the recent ruling, this affects organizations as a whole. Although the work is being done by individuals, should I be worried about my role in failing to meet accessibility criteria for content that I have created?
So let me answer that with a couple things. One is, I cannot give you specific legal advice because I have not run a conflict check for anybody on here. And also this is going to be posted on the internet. That being said, I will make sure that we put up either in the chat or something, my direct line and email. Feel free to call me, we'll chit chat. Second thing I'll say is, we should all realize our personal responsibility to accessibility. That being said, people in their, so public officials can be sued in one of two ways, right? Generally speaking, as in your official capacity or in your personal capacity. So a lot of the times when somebody is suing Governor Cooper, they're suing him in his official capacity as the governor of North Carolina, the entity that is the governor of North Carolina. Title II of the ADA can allow for people to be sued in their official capacity. So superintendent of whatever who created this improper policy. Title II of the ADA, according to the technical assistance manual for Title II of the ADA, does not extend to people in their individual capacities. And so I'll give you an example. In one case that I have worked, this was filed publicly so I can share it. Somebody had an issue about a fire inspection that was done and sued the fire chief in his individual capacity. Well, he wasn't working in his individual capacity. He was working as official, so that doesn't work. I hope that kind of answers your question as best as I can without getting way more into the weeds, but I'm always, I live in the weeds. I'm always happy to go there. I would also say on an employment level, I would check what the obligations are for you and your employer. Some places have started moving to, and I see this a little bit more in places like digital marketing groups, where they say you are responsible for making this accessible. And if this is not accessible and we get in trouble for accessibility, that's employment problems. So that's something else to be aware of. I would be shocked if that level of progression slash draconian enforcement has made its way to anybody on this call.
Awesome. Thanks so much for sharing.
Of course. I hope that helps. Please don't
Yes.
apologize for interrupting. Just say, hey, shut up a second. You're giving me excuses to drink my latte. I appreciate it.
No problem. If you could you
Yeah.
please push your camera down a little bit? We just want to make sure we see you a little better.
Of course. Thank you for the guidance on that. I appreciate it. Is that better?
Yes, thank you.
Okay. Thank you. That is very helpful for me to know. My forehead has given lots of legal arguments in virtual court. So again, when we are analyzing cases that come to us, the big things that we're looking for, especially now with these new exceptions or with these new rules under Title II, are the exceptions that we went over previously in the previous presentation. I'm just going to run through them again because they're important. Archived web content. So that's going to be content that was created or representing content that was created before the compliance date. It's going to be retained specifically for research or record keeping, not be updated or amended after the compliance date, and be organized in an area clearly identified as archived. So I could see an argument if you have, and we saw this more in law school, where professors would have their old exams online. And they were just there for archive purposes. That might be worth an exception, okay? And I feel like Judy's gonna jump in here and tell me I'm wrong, and I hope so, because I would like learning. Number two is pre-existing conventional electronic documents. That's any document on the public entity's website or mobile application that was there before the compliance date, unless those documents are still being used to apply for, gain access to, or participate in the entity's services, programs, or activities. So that is going to apply very similar to archive content, just content that's not there for research or archiving purposes. And the technical guidance on this new rule, if you're really curious or there's just a night you can't sleep, is really, really helpful here. It's very specific. It gives great examples of all of this. And it talks about what might get rid of these exceptions. The third is going to be a posting from a third party, unless that third party is posting due to a contractual licensing or other arrangement with the party. So the example that I talk about with this is if you have a calendar widget on your website that you are paying or have agreed in some licensing agreement that you can host their calendar, you're probably responsible for that content. Most of the time we see this in a space where people use like external credit card checkout. That might not be accessible. They're responsible for that content. Want to move kind of quickly here. Fourth, we talked, it was very, very well gone over. This is your password protected, individualized, secured conventional documents. And then your fifth is media posts that were posted before the entity's compliance date. Really important to remember here that even if something falls in one of these exceptions, but a disabled person asks for it specifically, you may still have an obligation to make it accessible. This is just what we're getting into on being proactive and the types of things to look for. We talked about conforming alternate versions before just a little bit. I can get into that at the end if people have questions. Long story short, under WCAG, you can use what's called a conforming alternate version. So what used to be very popular was Amazon was a big user of this. They had Amazon.com and Amazon.com/access, and access was the accessible version of it. Under the new Title II regs, you really can't do that. So here is a really, really important thing to remember. And this is not something to really heavily rely on, but this is a defense that exists other than undue administrative or financial burden, or a fundamental alteration, which are the big ADA defenses. So there are criticisms, genuine criticisms of WCAG that a lot of people have. One of the ones that I have is that WCAG is the most pass-fail exam there is. If you want to pass one of the WCAG success criteria about having all of your pictures be accessible, and one of your pictures is not accessible, technically you have failed that success criteria. There is a portion in the guidance for the new rules that says you can, as a defense, assert that while you have not specifically complied with WCAG, the lack of compliance does not impact the disabled person's use in any way. So the example that's given is one of the obligations under WCAG is caring about foreground, background, color contrast for text. You want some text that's easily viewable, either because it's brighter than or darker than the background, and it's specifically a 4.5 to 1 ratio. If you've got one that's a 4.4 to 1, but the person should still be able to use it, that's a really, really good defense. So a couple of the things, because I want to be intentional about giving you some practical steps and then open us up for some questions. So I'm going to return to our 3 North Stars. The first one is don't panic. When we panic, we rush in and make snap decisions. We can sometimes overspend. Something that our firm does that's pretty specific, that is one of my big areas, is I will sit down with people before they're audited for a flat fee or before they're sued for a flat fee, and do an initial audit and say, hey, what is the status of your website? How much work are you going to really need to do here? Because it may be as easy as bringing in a coder for 10 hours of work, or it may be so substantial that you want to pay one of the big audit testing organizations to do a full front to back audit and then pay them for extra hours to work with your developers. I've worked with a public client before where the only issue they had was that foreground background color contrast. I've worked with an entity before where after we talked for a while, they said, I think we just need to remake our website. I said, that's probably going to be your cheapest. So don't panic. Second thing is don't wait. So accessibility, I say all the time, it's plumbing, it's not paint. It's best baked in at the beginning, because if we try to retrofit it on the back end, it is harder and more expensive and more easy to break. And so use this opportunity now. Based off of the first presentation, folks, we have 3 years. This is a really good time if you are a decision maker to try to get room in the budget, to identify your audits, to start fixing your items. I don't know of a specific list of accessible offerings, but I will say I would be shocked if there weren't listservs out there for people, or Facebook groups or LinkedIn groups where everybody around the country in public education is going through exactly what you are now. And so there's probably comments there. I will also say a lot of providers will do a free week trial. That trial is the perfect time to do your accessibility audit, see if it's accessible. If you're procuring something new, getting into a contract, if you want to talk about that, give me a call. We have language we put in there that protects you, puts obligations on them, and if you get sued and it's over something they did, will help you there. The third thing I'm going to say is don't rely on what somebody says, okay? We talked about this earlier. You'd never buy a house based off of somebody else's report or inspection. You're going to do your own inspection. It's the same way with accessibility. Don't take a seller's word that their product is accessible. It's probably statistically not. In a 2023 study of the 1 million most popular websites, 90% of them were inaccessible, and the average number of errors found on the homepage of these websites was 50. So it is very, very likely that it's not going to be accessible. So do your own testing, verify, the same way of getting any sort of software. I'm in the data privacy practice as well. And you would never just assume something's secure and start putting personal information in it. So what can we start doing today, especially knowing that budget is an issue and that our authority is an issue? The first thing, this is a little bit controversial, but to the extent you're able to make this decision, I would stay away from widgets. Widgets are pieces of external third-party code that can be added to your website that allegedly make it accessible. They usually don't. They usually make it more accessible. Usually what they try to do by making it accessible is just redirect disabled users from the inaccessible content. There are so many problems with accessibility widgets, and so that's something we can explore. I would start by analyzing, at least find an automated checker you like and start using it on your work. Don't forget that when you're doing this work, to the extent you're a decision maker, you have to keep other laws in mind. I specifically look at the intersection between digital accessibility and data privacy. Train your posters. If you have a tech, train them on best practices for creating accessible content, including things like alt text. I would start identifying what areas are exempt and the areas that are not exempt, start working on making them accessible. Now, the most common issues we see in this space are going to be content that are not read by screen readers. We're going to see content that can't be navigated with only a keyboard, images, links, and objects that lack meaningful text, and videos or audio that lack transcripts, captions, and audio description. If you have procurement opportunities coming up, this is a good time to explore it. When you're picking textbooks, if there are online websites for those textbooks, check for their accessibility status. So I want to save as much time as I can for questions, so 4 minutes, but let me just end by saying this, that our society has done a really, really good job of putting the onus on accessibility on the people that have the least power. And our society has done a really good job of separating persons with disabilities from everybody else. And so having questions about this space, maybe being a little worried about this space, is completely normal. But don't rush and don't panic. Don't wait and don't rely on everybody else. And most importantly, realize that the biggest factor for creating an accessible service, classroom, and world is to care about accessibility. And the fact that you all are on this call at 10:47 in the morning on a hot June morning is demonstrable evidence that each and every one of you cares about accessibility. And so I just want to say thank you for that and take what time I can for questions.
Okay, awesome. Thank you, Derek. You did already answer one of them, but I just want to read it out
that good.
You are, just to see if you have anything else to add. So the question was, do you think that the use of different website widgets such as UserWay, AudioEye, etc., which help make websites accessible, are a good tool to invest in to help schools and make sure their content is accessible? Anything else you'd like to add to that?
Yeah. The increase in litigation against individuals, especially under Title III, the two new trends we're seeing in that are people who are getting sued for the second time and people who are getting sued using accessibility widgets. I'm not going to speak about any provider because they're very litigation heavy and I don't have time for that. But lots of people are being sued over these widgets and their offerings are still being found to be inaccessible. So I would, for compliance reasons and accessibility reasons, strongly consider avoiding them, especially until the technology gets to a better place. It's just not there.
Okay, thank you. Next question. So if we have a contract with a third-party vendor and they claim that their platform is accessible, what is our responsibility in making sure that they are stating a true statement? If we run into a complaint regarding accessibility related to the vendor, would it be our liability or the third-party vendors?
Sure. So let me answer that in two parts. Again, with I can't give you specific legal advice. Give me a call about what's going on. I'm happy to work with you. Our firm has also authorized a flat rate to help because we recognize that this is could be an expensive area. So feel free to give me a call. As to your first issue, yes, you have an obligation to make sure that it's accurate, in the same way that if somebody says this textbook is great, get it, you would probably check that textbook to make sure that it works, right? As far as switching of liability, you do have that liability, you do have that responsibility, and you are unless your contract says otherwise, you're going to be responsible. It's the same way with landlords and businesses, right? If a landlord has a multi-tenant space and one of the tenants is inaccessible, either the tenant or the landlord can be sued for that. Outside of state law changes that aren't present here, yeah, it's going to be on you, not the creator, which is why in those contracts, you want to have your procurement agreements and you want to have indemnity. That basically them agreeing that if we create something that's accessible and because of what we created, you get sued, we are responsible for paying your fees, or you can sue us for contribution. That is a very, very smart thing to do that not a lot of folks are, that I'm happy to talk to people about.
Okay, thank you. And the next one is asking for recommendations. So what is the name of a good automated checker?
I am a big fan of DQ Systems. They're one of the bigger users in this space. And I use DQ's Axe, which is a free Chrome browser extension. There's a paid version as well that gets into even more work and does intelligent guided testing. I like DQ a lot for that. I also used them to study for my CPACC, which is my certification in this space. Also, quick note, if you're going to use auditors on this, look for people that have certifications or demonstrated experience in this space. There is a growing number of quote unquote experts that just say, I'm disabled and have used the internet my whole life, so I'm an expert. That's not accurate, right? But DQ has a lot of really good education opportunities as well. And I believe they do, I know they do discounts for, education providers. I know if you yourself are disabled, you can request a scholarship to get to all of their training materials, last I saw, for free.
Okay,
Wave is good as well. Wave testing is great.
Okay. Well, awesome. Thank you, Derek. That's all the time that we have. We certainly appreciate you sharing your expertise with us today. Alrighty.
Perfect. And I should have just put my direct email and office line in the chat. So please feel free to reach out to me if you have any questions, want to discuss any of this more, or if we can be of service to you.
Right. Excellent. Thank you. And also, please remember to complete the conference survey after at the end of today. I did go ahead and put up the slide again, and there is the QR code. So thank you.